Good afternoon, everybody. Just firstly, just the quick sort of 30-second elevator pitch. I don't know, I think a lot of you in the room probably already know Taylor Wessing. We are leading international law firm, although proudly with an office in Cambridge, just on the Hills Road, just up from the station. Do pop in and say hello. Can you not hear me? Sorry. Okay. We'd be very pleased to see you. So location-based services, I feel at a little bit of a disadvantage here in some ways. We've seen Kanwar and Anglia have been talking about lots of new exciting technologies and services and things, whereas I'm standing here about to tell you about a whole bunch of ostensibly old laws, but I suppose therein probably lies the problem in much of what I'm about to say. So, general topic I'm going to talk about is regulating location-based services. There is a legal regime already has been implemented. It's well in force. As we say specifically at the bottom, a lot of it comes from the data protection regime, stemming from e-privacy directives, the Data Protection Act in the UK. There's a whole load of sector-specific regulation as well, both from Europe and from the UK and the other jurisdictions. Basically, the good news as far as use of user data in all its various shapes or forms is that interception, retention and processing of user data in any sense, but including from mobile phone handsets, is heavily regulated. The law doesn't make, to a great degree, the law doesn't make a massive distinction between use on a mobile platform and use in other settings. So the legislation is to a certain extent future-proof, technology-proof to that extent. When we're talking about user data, we could be talking all sorts of different things. And if you look at the data privacy laws, if you look at some of the regulations that are relevant here, you'll see different types of information are classified. One example is communications data, which is really information used for billing purposes and traffic purposes and things like that. There's obviously the much broader category of user data or personal data, which is information specifically relating to individuals, names, addresses. It could be locations, but it could be all sorts of preferences, just basically any information that relates to a particular individual on a subject basis rather than, for example, to a corporate. In this whole plethora of privacy legislation, we do have a particular category of location data, which is a specific area which is legislated, it's regulated by itself. As we sort of say here, e-privacy directive is relevant, and in the UK, the primary instrument is actually it's Regulation 14 of the Privacy and Electronic Communications Regulations, which are shortened by those in the know to the PEC regs. So if ever you hear a lawyer talking about the PEC regs, that is what they're talking about. Location data specifically is defined as any data which is processed which indicates the geographical position of the terminal equipment, mobile handset, but it could be other things, of a user. Now the definition has been stress tested to a certain degree because it includes information not only relating to the latitude and longitude, but also the altitude of the user and where they are, the direction of travel, and also the time the location information was recorded. So all that stuff we were hearing earlier about geotagging and photos and that kind of stuff, that's potentially going to be location data for regulatory purposes. Processing of location data. You'll be pleased to know you can't just do what you want with it, although you can't do anything, you can't do everything with it. There are restrictions here. Location data, the rule that comes from Regulation 14 is that location data may only be processed if either A, the user cannot be identified by the data, or B, the location data is necessary for the provision of a value-added service and the consent of the user has been obtained in advance. So you've got two potential routes you can go down. Firstly, if in gathering location data on the network, you can genuinely say that the information is anonymous and there's no way of identifying the particular individual through use of that data, then you can use it within the system and there are fewer restrictions in terms of what you can actually do with it. Now, of course, the issue is it might be anonymous in one particular database, but if you also have some other information which you could put together to actually piece it together and actually work out who that person is, then the information isn't truly anonymous. So you have to be very careful about the context that you're receiving the information in, what other information you've actually got that you could put together with it. Because, for example, using a code number or some kind of anonymized account address or something for somebody, if you've also got a lookup chart so you can find out actually it's Patrick Clark from Minchinhampton, Gloucestershire, then that information isn't anonymous anymore, unfortunately. So a lot of the time you might be fortunate enough to be dealing with anonymous data, but quite often it is possible to identify the user, so you often then end up looking at the second potential way through this. Now, if the user can be identified, you have to ask the question, is the processing necessary for a value-added service? i.e., it's not just because you've got it in the conduct of that service, then you can therefore use it for any reason. You've actually got to be using it in relation to the provision of that service. So that should impart certain logical restrictions as to what you can do with that data for that purpose, although I think one of the issues there is that the boundaries are probably a little bit grey, and particularly it depends how you define the service. And secondly is the issue is that has the user given consent? That is the other big grey area here, because there's a little bit of a debate around what consent actually means in this particular context. So just looking at consent and the definition of consent. Firstly, consent generally needs to be given as a positive indication. It's got to be specifically given. It's got to be informed as well. So the user, in ticking the box or unticking the box, whichever way around that they work it, they have to know what it is that you're asking them. You can't just say, can we use your data? That doesn't really tell them what you're going to use it for. But there's also the line, as particularly in mobile platforms, the mobile internet potentially is you can get a lot more information out there than you can on a text message, for example. But for example, from a practical perspective, is a user actually going to take the time to go into the website and go through 30 pages of T's and C's and potential purposes and things like that? So you've got a practical restriction there. So whenever you're sort of ostensibly getting consent from a user on the move in particular, you've got to be very careful to make sure that they've actually had the right amount of information so you can demonstrate that they've given you informed consent. If the consent isn't informed, then it's potentially invalid and doesn't get you out of jail in a figurative rather than literal sense. We say that the consent usually has to be given up front, so it's not a question of seeking consent afterwards. It's usually got to be a click-through or a positive affirmation before you start using that data. So, for example, it's a bit of a cliche, but the typical example is you download your new app from the Apple App Store. I use Apple. I'm sure that the Android platform works in exactly the same way. First time you fire up the app, it says XYZ wants to use your location, deny or allow. And I think that's very much become the convention as to how we do it in practice now. So clearly, before you're able to use the app on that occasion, you have opted in, you've given your specific consent, you've given it in advance. The question is, I suppose, from a legal perspective, and I think it's one that hasn't really been explored fully yet, is to what extent is that consent actually informed? Because they've just said they want to use my location. The whole question there becomes, well, what are you using my location for? And I think that there's no sort of, the regulations, given that they were drafted about 10 years ago, don't go into sufficient detail around how much information you have to give. Positive thing is that the Information Commissioner takes a rather pragmatic view as to the level of consent and things like that. So there's an awful lot you can imply in terms of the context in which for example, the service is being provided, what the user's reasonable expectation of it is going to be. So putting a statement out there, if I've downloaded a Where's My Nearest Chip Shop app and I've been asked if they can use my location data for that, then yeah, I'm going to expect it to be used for chip shop purposes. You might end up in an interesting debate, though, whether it extends to other fast food restaurants, car showrooms, and all sorts of other potential applications and vendors. Also key at this point is that having given the consent, you also have to have, in most cases, and I say in most cases because that's actually how it works in practice, the user has to have the opportunity and the ability to withdraw at any time, including, in some occasions, each time they actually connect or use the service. Now, I've noticed in my proverbial chip shop app that what actually happens is that it only asks you once. So it doesn't ask me each time I fire it up whether I still want to use my user location information. Now, from an Apple platform perspective, I do have the ability to turn that off. In going into the settings, I can look at the location services settings and I can uncheck the box. I can uncheck it permanently, or I can uncheck it on a temporary basis. So ostensibly that fulfills that parameter. The fact that I was looking at it from a regulatory perspective and I was curious as to whether I did have the ability to turn that off, and I had a little bit of information about the regulation sitting behind it. That was obviously helpful from my perspective. It's a moot point perhaps as to whether the rest of the population, whether everybody will know that that setting resides in the handset, in the options in there, and whether that's actually the easiest way of doing it. I said about the regulators being very pragmatic in terms of how they handle this area. I think there's a certain sort of recognition that these sort of practices do get people most of the way there, and I think it would probably take something quite controversial to happen in order to get people to really sort of scrutinise those sort of operating processes in too much detail. But you do start to sort of, once you start looking at the definitions and how maybe the practice sinks in what the law actually says, there's certainly, as us lawyers love to see, plenty of grey there for those who are looking. Last discussion there is about opt-in against opt-out. Whenever you get more than 3 data protection lawyers sitting in the room together, they will often go into reams of discussion about opt-ins and opt-outs and which is the best way and which is the safest way of doing things and which protects the user better and how does it all work and how do you implement it. Thankfully, the Information Commission has now taken the view that actually opt-in, opt-out doesn't really matter. As long as there's the clear process there for giving consent is actually demonstrated, then frankly it doesn't usually matter. Although that then sort of takes us on to the sorts of issues we were mentioning about where things are maybe going in the future with privacy being a default option and maybe driving it more towards the kind of opt-out as being the sort of the logical conclusion there. So service providers' obligations, what do you have to do if you are a respectable service provider? And service providers would catch in this case both the communications provider, so the telecoms network, the Vodafone, the O2, who's providing you with a service, but also it attaches to the value-added service provider. So my friends who've set up their fantastic chip shop app. Firstly, the service provider has ultimate responsibility for complying with the privacy regulations and for general data protection in its fullest sense. So to the extent that we've identified that we are using location data, you have to make sure that you're only using it for the permitted purposes. Clearly, the extent to which you're receiving other data, particularly personal data, you've got to make sure that you're doing it fully in line with the Data Privacy Act, with the data privacy principles. You can only use it in a fair, reasonable basis. You've got to have security things in place, all that kind of stuff I'm sure you're used to hearing about. The key point here again though is that anything that you do, really, it all comes back to consent from the user, and it comes down to informed consent as well. So it always takes you back to that question as to have you done enough in the first case that validates what you're doing. Retention is another interesting issue. There's some information there, for example, retention periods on subscriber and telephony data, billing data, things like that. This 2-month period isn't any sort of definitive legal benchmark, but location data, the concept here is that location data should only be retained for the length of time it's necessary in order primarily to provide the relevant service, which I think goes down to your issue of relevant location. There has been some commentary that whatever you're doing should be subject to a 2-month maximum. The principle there being that even in a worst case scenario, that ought to be long enough. If somebody's got any questions or queries later on as part of the process, that beyond that point you really shouldn't need to know what the end user has been doing. And frankly, in most cases, that 2 months is probably going to be too long as well. Should you wish to hold on to the data for longer than 2 months, then, excuse me, then usually the only route of doing that is to anonymise it or to aggregate it. Practical issues, just a few sort of final points. So, firstly, can you anonymise the data? Is it possible? Does it serve the purpose? In a lot of the cases, the kind of services that people are going to be providing, you probably don't want to anonymise that data. There might be things where it doesn't matter so much who you're providing the service to, but I think the issue with a lot of these services that because people are building ecosystems, you've got the Apple operating system, you've got Android, you've got a lot of apps which talk to each other, and they allow the user is getting an advantage of connecting maybe their different accounts in different spaces, and maybe the user doesn't necessarily want it to be anonymized in that way. It kind of tends you towards, well, it might be possible sometimes to anonymize it, but in a lot of the cases, you're actually going to be in that space where you are firstly having to get consent, and secondly, you're having to make sure that you're only using the data that you're driving through the use of the people's services for the very specific purposes of providing them with that service. Now, providing them with that service almost certainly doesn't include selling that data onto a third party who might want to provide them with a different service. It probably doesn't extend to analysing that data to see what other stuff that end user might want to be sold by you, which is similar to the service. Although, again, it comes down to how informed was the consent, because if you make up, you're used when you making contracts online, for example, ticking in and out of boxes to get information from third-party providers or information about other services and things like that. And this is all part of that framework, really, because if you communicate enough to the user about what you're intending to do long-term with the information you're gathering, and you can demonstrate that they've positively agreed to it, then from a sort of a regulatory perspective, that does often make things a lot more possible. But of course, you've got to balance the fact that that's fine if you've got a completely clean database. But if you've got some people have opted in, some people have opted out, some people have checked boxes, some people haven't, as is their want, you never quite know whether you can just apply the same standards across the whole base. I think particularly as well, we've got issues, we're talking location-based services, which kind of drives us more towards, again, a mobile internet sort of environment. People from experience, and maybe it'll change as people become more used to using the mobile internet, but I think people, I said partially earlier that it's a lot easier to present people with the information, but they don't necessarily have the time. They're perhaps moving, they're not actually physically able to read through the information. They don't want to be presented with a whole load of screens and tick boxes and options that they have to navigate before they get to the service. I'm sure that in terms of designing apps and things, the fewer the clicks you can get to before actually getting into the service, the better. The less chances you give somebody to say no, the less likely it's ultimately going to happen. So it's striking that balance between what works from an end user experience and from a service perspective in terms of getting the right level of information over so that you can stand there with your sort of bulletproof response that it was consent gov and it was informed consent as well. One final thing I just thought I'd just comment on, it's not on the slides, but there is, I sort of said I was sort of rather embarrassed standing talking about old law. Some of this stuff on location data has come in more recently than 2002, 2003. There have been developments, but fundamentally the data protection regime has been in place for about 10 years now in its current form. They are, much like the initiative we saw from the Canadian Information Commissioner, they are currently thinking at a European level of another refresh of data protection, data privacy laws in Europe. We're expecting, I believe, a consultation later on this year, which, given typical sort of European mechanics, may take till 2013-14 to come into legislation. But so a number of the issues that Andy in particular highlighted on that slide are going to be under discussion in Europe now. So, for example, privacy as a default option, privacy being embedded in the system so that people are going to be encouraged, incentivized and or cajoled into building privacy and security measures into the underlying technology, which in a way that maybe they aren't at the moment. The right to be forgotten online, which from a sales and a marketing perspective is probably an anathema, but we get this whole thing about sort of people signing up to Facebook and not being able to get out of Facebook. What goes on the web stays on the web is kind of how the world seems to work at the moment, and they're potentially going to look at that from a privacy perspective. So it'll be interesting to see how that pans out. And also just looking again at the sort of the details to the security obligations and what network providers have to put in place, maybe what service providers have to put in place, what sort of levels, whether it's encryption, whether it's other more even contractual measures of securing people's information and securing their privacy. So it's even though we're sort of talking about some fairly old law, it's a constantly evolving framework. It is reactive to new technologies, although typically, I mean, data protection is very much like the telecoms world in that you tend to find that every 10 years or so they'll issue a new bulletproof technology neutral regime which is out of date almost the minute that it's actually implemented in country, and then everyone's playing catch up until they can get the next regime to maybe look at it again five years later, so it's not too far out of date. But fundamental message, I suppose, is that it's not the Wild West. There is a fairly well-established body of law and regulation that covers the subject. It's not hugely complicated, but there are certain things that you have to do as a responsible service provider. If you're building these kind of technologies or these sort of applications, there are things you do need to factor into your decision-making process, and particularly your flow charts as to how things are going to work and what information you present to the end user. And also, unfortunately, there are consequences if we don't do so as well. So data protection is one of those areas that the regulators are working often in a very resource-constrained environment. And they don't necessarily go after everybody, but if you're big enough and if you put your head above the parapet, and from a press perspective it's worth them doing it, then they will certainly come after you. I think the case, everyone probably saw Google yesterday being slapped with a not insignificant fine for misuse of, among other things, location data through Google Latitude yesterday, and that's the sort of scalp that the regulators, it is worth their while because that sends a message out to the market in general. So I think that was all I wanted to say. Thank you very much.